class coming up on June 7th and 8th with Carmela Ma. If you're interested to complete your CCIM, I highly, highly suggest you attend her class. She is amazing. I know some people took her class earlier this year as well. Also, next week, we're going to have a class talk about business opportunities and business escrows. And on Cinco de Mayo, we'll have our commercial mixer at Brickworks. If you haven't signed up, just go online to SBAR, sign up, and show up. You're going to run into a whole bunch of other commercial brokers and agents that you may not have seen or run into. One last question or piece of information. Hold on to your questions. Let us get some flow. I've already asked our attorneys for some basic questions that they usually get all the time. We'll go over that, and then at the end, Nikki is here with us. She'll just pass around the mic and let you guys ask all your extra questions. Oh, okay, Bill's here. All right, let's get started. I'm going to start with Holly, ladies first. So Holly, can I withhold parts of contingencies in a contingency removal using the CR form?
No. So I find that this is a real problem for commercial agents. I do both transactions with my residential agents and my commercial agents. And what I find is that commercial agents like to show good faith to remove contingencies, but they don't have the environmental finished, or they don't have the something with the tenants finished. And so they want to remove all contingencies except phase 2 report. And I don't know about you, but I could look in the contract all day long and I won't find a contingency for a phase 2 report. Because what does the phase 2 report fall under? Falls under investigations, right? So if you remove all contingencies except phase 2 report, you've essentially removed all contingencies because there's no such thing as a phase 2 report contingency. So what I try to get my agents to do, and they're not really good at it yet, but we're working on it, is to say on an addendum, not use the CR form, because remember, you can remove contingencies in a lot of different ways. The contingency removal form is one of the ways, is you go to an addendum and you say, buyer removes all contingencies except buyer will have a new contingency to review and approve the phase 2 report by and give a date. Now what have you done? You just created a brand new contingency for your client for the phase 2 report review. And then there's no question about, well, did I remove all my contingencies? Did I not? Yes, you removed everything except you gave your client a brand new contingency. So be careful on that CR form where it says other and you just get creative. Agents have creative writing skills that are unbelievable, okay? So be careful that whatever you write in that other is a contingency that's listed on the contingency removal form. If it's not listed there, you can't write it on the other. You got to create a separate one for yourself. Does that make sense? Yeah.
Thank you, Holly. So back to Jim. Jim emailed me everything, so I love this, digital and electronics. I need to perform some maintenance inside an apartment, but the tenant won't let me in. How can I get in and do the work?
Okay. This is like from my clients that are property owners or landlords. And one of the most biggest problem I see is buyers of apartment buildings, especially apartment buildings, mom and pops especially, don't understand that it's a business, that they're buying business, and each apartment, each unit is an individual business. They look at it as just an investment. Well, the investing part stops when you close escrow. Okay? Then the business starts. And many, many people buy, a duplex, a 4-unit building. It's just a rental. It's just an investment. And it's a nice thing to supplement my income, and everything's going to be just wonderful. No, it's an active, ongoing, high-risk business. Now, it's not a full-time job, and it's not hard. But you have to understand that you're now a business owner, and each apartment is its own little individual business, and that you better learn the business before you close. Because after you close, then you've got what you got. And it's kind of late. It's like me opening a grocery store. I'll go out of business real quick. I don't know anything about inventory control or anything like that. Many landlords just buy it. Oh, okay. And why did my realtor tell me? Well, it's not. Their job is to help you buy the property and make the investment, not to teach you how to be a business owner. But this gives me a real clear indication that this is a landlord who really has not taken the time to be as up-to-date and sufficient in their knowledge in the operation of the business. Gaining lawful access is one of the big problems I see with landlords. They don't know how. Okay, well, the law covers it, and you can't go in just to have a look. And so the short answer to it is you have to prepare and serve a 24-hour notice of landlord's intent to enter only for those reasons. And when somebody says, my tenant won't let me in, I said, there's a landlord who doesn't know his job. Because if you serve a proper 24-hour notice of landlord's intent to enter with the proper reason, and you show up out there with your worker, your plumber, your maintenance, your realtor, your appraiser, your building inspector, whatever, and you want to get into your tenant's units for those reasons, and the tenant says, no, you're not coming in, you evict them for it. Even in rent control. State law and even every rent control law says denial of the landlord access is one of the bases for evicting them. So the tenants don't get to do that. On the flip side...
Jim, do you have to give them a notice to cure that?
Split in authority.
Okay.
And I have a split in authority. My office did. My position, and it was taken up on appeal, and it's still split because it was unpublished, is that the 24-hour notice is the notice. Here's the reason. We're following the law, Civil Code Section 1954, I think it is, and let us in for this lawful reason. And that's the notice they get. If they breach that, if they don't let you in, then that's violation of the law, violation of your right to come in, and you should be entitled to a 3-day notice to terminate. Just there's no cure or quit. I did that in one case. The judge said, yeah. Went up on appeal, and the appellate court said, yeah, but they didn't publish it. So the safer thing to do is, you serve a 24-hour notice. They don't let you in, and then I do a 3-day notice to perform or quit, saying, okay, we did this notice. You didn't let us in. I set the date and time, and you will let us in. Otherwise, you'll be evicted. And in the last 4 years, it seems like I've gotten a whole lot of these tenants denying the landlord access. And when we finally get to trial, and they always fight, the judge kind of goes, well, wait a minute. All the landlord wants to do is come into your place to spend his money to make your place better, and you're denying him because? And the tenant just, deer in the headlights type thing. And they don't understand the rational bit of it. But that's basically how you do it. And it's a big problem, learning how to gain lawful access and doing it precisely. If you miss any little step in the process, then the tenant's right. They can deny you lawful access. What's the landlord trying to do? Go into the privacy of somebody's home without a warrant. So it's a serious thing. On the flip side, the law puts the burden on the landlord, the property management company, to do certain things for that tenant, maintain habitability primarily. So you have to do it, but you have to do it right.
Jim, if they go there and the tenant's not there and the key doesn't work, what does the landlord do?
You can, I've had this. You can, I tell my client, pick the
Sorry, I got agents that constantly call me with these questions. I might as well get you to answer them for me.
Hold your questions till the end if you don't know. I'm just kidding.
Well, that applies to me too.
No, you can pick the lock. You hire a lock. If you've done the 24-hour notice, you've got the lawful right to go in. You don't need the tenant's consent. They don't need to be there. That's why the law says you can only do it Monday through Friday, normal business hours. Well, that's not a problem. Most tenants should be at work at that time, so it's not inconvenient. And most contractors work normal business hours, so it's not inconvenient for the landlord. But if the tenant's there saying no, or if they've changed the locks on you, you better have a contract that says they can't change the locks, a lease agreement, with that in there, and the CAR does. I think most decent rental agreements do that. But yeah, you can pick the lock, but you cannot change the lock. You can pick the lock and get in, but you cannot change the lock. One real graphic example broke my heart. About 4 years ago, I was reading in Orange County, a landlord bought a property, didn't know this, and wanted to do some work in the tenant's apartment, didn't give him a notice, went over there, used his key, opened the door, and the tenant shot him right inside the front door, dropped him dead, right in the chest. It was graphic. And he's dead right there. And then police roll out and all this, police says, what's going on? He says, I don't know. I think it's my landlord, but he just opened the door and came in. And I shot him. I didn't know who he was. And they go, okay, And the widow of the landlord was incensed. He murdered my tenant murdered my husband. No, he was trespassing. Mm-hmm. I said, there's a landlord who paid with his life for not knowing this stuff. Mm-hmm. And so that's why I started with that question. It's really a serious thing. You're going into the privacy of somebody else's home without a warrant. There's an inherent right to the privacy to be secure in our persons and property, U.S. Constitution, right? And there are exceptions to that. With a warrant, if you're the government and you're going to go in, landlords are the other exception. You don't need that tenant's consent. You don't need a warrant. It's a pretty powerful thing. But you need to get in there not to have a look. The law is real clear. You cannot go in to have a look, but I can always get you in for another reason to have a look. But you must follow that law precisely. Then you should be safe. The tenant knows you're coming, and they know not to shoot you, in general. So that just broke my heart. I said, there's the landlord who paid with his life. And then the widow hired a lawyer and wanted to sue for wrongful death. I said, well, this lawyer's an idiot for taking the case on. There is no wrongful death. He's a trespasser. And the judge threw it out in civil case. So both no criminal prosecution, and the civil case judge threw it out. And so the widow's a widow. And so this is serious stuff, especially this issue.
Thank you, Jim. So Bill is here with us as well. Bill is going to talk about the new laws. So I'm just going to go to Bill from time to time, and he'll just take it on. So.
All right. Sorry I'm late, everyone. I actually had a telephonic conference with a judge. It started at 8:30, and he didn't take my call and do the conference until 9:15, which kind of shows you the way the court system is working right now, very inefficiently and very ineffectively. But sorry I'm late. I want to basically tell you some of the new trends, new laws, or cases that have come down that kind of affect how you might want to explain things to your clients and just for your own personal knowledge and so forth. I tried to pick things that I thought might be necessary for you to do your job as a realtor, and also just kind of on the interesting side of the way things are going in this world. The first one is there's an Orange County case that happened regarding a landlord failure to allow tenants with mental health disabilities their special pet, their special support animal. Yeah. And you've seen this on airplanes and so on and so forth. People are now claiming that they have mental health problems and they have to have a support animal. Well, in this case, the landlord got sued and found against the landlord for making and requiring like an additional pet deposit and size restrictions on the dog, which kind of breed and how big they can be and so forth. And that the landlord failed to do an interactive process to verify that the tenant had genuine disabilities. So just to let you know, it looks like that people who claim mental health needs for a pet are going to be allowed to bring their pet into an apartment building, or they're going to have some, a landlord can get into some serious financial difficulties for that. There's a big award against the landlord in this case. Yes.
Hold.
People with mental illness are not considered a protected class, though, correct? So is it okay for us to ask if they have mental illness?
Well, I think it's okay to ask, and you're also allowed to verify. But my experience has been that doctors will sign about any kind of letter that a patient wants. And there's a lot of fraud going on out there about people saying they need a mental health animal. So that's something you can try to verify it, but if it seems real or verifiable, then the landlord better back off and allow for the pet.
You can't ask exactly what is your disability, but you can ask for verification of it. And I always tell my agents, your landlord can ask, how does this animal assist you with your disability? That's a question you can absolutely ask. And if they stumble, then they probably don't actually have an answer for it. But most of them, if they've been coaxed on this and coached on it, then they know what they're supposed to say to that. So.
All right. Let's hold the questions. At the end, I'll give everybody an opportunity. This is the important one for Holly. How did I create agency when I didn't even think I was representing that party? How did I do that?
So agency is created by your behavior, not by forms. And I think that agents mistakenly think that if I give an AD form, then I've created agency. And that is completely false, because the AD form, you are supposed to deliver that to a potential client as quickly as practically possible when your relationship has changed from casual to business. And that's a lot of gobbledygook to say, that when you no longer are chit-chatting about the wine and you've started talking about the real estate market specifically and how it affects them, then you've moved from casual to business. But that doesn't mean you have to have an AD in your back pocket, And it doesn't mean that they've actually become your client, because they don't actually become your client until they're relying on you for your real estate advice. So while you may be chit-chatting now professionally to the extent that you're supposed to have an AD form, they may not actually have created an agency relationship with you yet. However, if you're out there cold calling and you get some seller who says, sure, you have a buyer for my 8-plex, I'm happy to sell it to them, but I don't want to pay you commission. I don't want you to represent me. And you say, great, that's all right. My buyer will pay my commission. We'll take that. So then you go through the process, and then every time the seller has a question, you answer it. Seller comes to you and says, well, what do I do about the fact that my tenant didn't pay last month? And you say, oh, well, let's talk about that. Well, what documents do I need to deliver to the buyer? And you answer that. And every time they ask you a question, you answer it. The seller is relying on you for the advice during his real estate transaction. You are now his agent, and you're working for free. Which, I don't know about you, I don't work for free. I'm pretty sure you hate working for free. So if you are going to be in a situation where one side says, I don't want you to represent me, first, try to convince them why that's not a good idea and why you bring value to them and so that you should be representing them. But if they really don't want to be represented, there's a form for that. There's always a form for that. So the form is seller non-agency or buyer non-agency. It's an SNA form or a BNA form, depending on which side you're on. And it says, I don't represent you. You know I don't represent you. You can go get somebody else at any time to represent you. Just know that I'm not it. But then your actions have to follow that. So when they call you and they say, my tenant didn't pay, what do I have to do with that? You say, well, of course, I'll pass that information on to my buyer, but what you're going to do with it is you need to consult with your own counsel to find out what you need to do with that, or talk with your accountant, or talk with somebody else besides me. And it will feel awkward to you because you're so used to answering people's questions about real estate, because that's how you get your business. But you have to draw that sharp line when you're in a transaction and you don't represent someone. Because if you don't, you've just taken on liability for the other half of the transaction, but you're not protecting yourself by making sure that they're doing all the diligence they need to be doing. You're not protecting yourself by getting your file completed for that half, and you're not getting paid for it. It's a bad, bad situation, lose-lose for you all the way around. So better to convince them why you should represent them and get paid for both sides.
Thank you, Holly. So back to landlord issues, Jim. One of my tenants told me that they're moving out next month. They want to use their deposit for the last month's rent. What am I going to do?
Okay. How many of you think that it's okay to take first and last month's rent? Oh, thank God. Okay, good. I still hear that.
I hear it all the time.
I still hear it. And it hasn't been around since before I became a lawyer. And for 30, I don't know when the law changed. It used to be years ago, decades ago, that you could collect first and last month's rent, and a deposit. No. The law changed 35 years ago at least, because I've been practicing for 28 now, that you can collect a security deposit, which is the equivalent of 2 months' worth of rent for an unfurnished apartment. Okay, that's the maximum you can collect as a security deposit. And it's important for landlords, property managers, and realtors to understand that money is in landlord-tenant is different. There's rent, and there's a specific definition. It's a legal term. Then there's security deposit, and then there's fees. And they're three totally separate things. There are three totally separate ways of collecting them and enforcing them, and they're different on your rent rolls, and they're different by IRS standards. But all tenants want to do that. So it's a very, very common, extremely common thing. Use my last month's rent. No, you didn't pay last month's rent. Read page 1 of your contract about security deposit. And in the CAR form and the AOA form, it says it in big bold. It will not be used as last month's rent. And they don't know. Tenants don't know. They don't care. They want you to use it. Can you use the security deposit as last month's rent? Yeah, it's legal. You can. But then you're unsecured. So rule of thumb that I tell my property managers and landlords is, once you collect deposit at the beginning of the tenancy, and you better collect it, and there's ways to collect the maximum, and you should, okay, you forget about it. You don't even think about it until that tenancy is over, until that tenant is gone, or until you evict them, or until they deliver up lawful possession. That's the key there. When do you have lawful possession? And the second the landlord gets lawful possession, the first thing I tell them is on your mind is security deposit. Not, oh, I got to get in there and clean it up, and I got to put a rent for rent sign, and, well, I got to change the locks, yeah. But you have 21 days to account for it, written accounting for it. And that's when you take it out of unpaid rent, hopefully there's not, and damage and cleaning and judgment and attorney's fees if you have a judgment on them and all that. So no, do not use security deposit during the tenancy, because then you're unsecured. If you think about it, it's kind of common sense, but I see it all the time. Landlords use it, and they go, well, the tenant wanted me to use his deposit. I said, no, it's his money, but it's yours to use, okay? And again, this is Landlord 101, basic stuff, gaining unlawful access, accounting for the security deposit, collecting rent, they know how to collect rent, So, so don't use the security deposit as last month's rent. Account for it once the tenancy's gone, and the best thing to tell tenants is, I have to follow the law. I love that phrase. They want to run your business. They want what they want, and no, we do have to follow the law. And so I have to follow the law. I know what you want, and gee, I wish I could help you out, but I have to follow the law, and leave it at that, and they stop arguing. So it's easy.
Thank you, Jim. Bill, back to you.
All right. A recent case came out that basically provided that a homeowners association for condominiums is allowed to charge additional fees and costs for short-term rentals. So a lot of that's going along around now, where especially in like nice beach areas and so forth, where homeowners associations are getting tired of having short-term, week-long rentals, overnight rentals, and all that kind of stuff. And so this homeowners association instituted additional fees because the additional traffic of what a guest or a vacationer typically does. They have more people over, they have, they use things more, they do all kinds of different things. They usually lose the clickers on the garage door, you name it, they do it. So it is legal for a homeowners board to do rational additional costs and fees for the short-term rentals. What I did, just for fun, is I checked with the 3 cities, Redondo Beach, Manhattan Beach, and Hermosa Beach. And right now, Redondo Beach is saying that short-term rentals, sometimes they call it Airbnb, short-term rentals are not listed as an allowable use, so therefore it's not allowed. That's the city of Redondo Beach's position. Manhattan Beach did just recently pass an ordinance saying that short-term rentals are prohibited. And Hermosa Beach says that anything less than 30 days in the way of a rental is prohibited, but it's a $100 fine. So that really doesn't scare too many people away. So it's not very effective in Hermosa. But it is a trend that's growing, and I think the big news is that homeowner associations are allowed to charge a little more and get additional costs and fees that are reasonable because of the short-term rental use.
Thank you, Bill. Back to Holly, we're going to talk about ethical conflicts. So Holly, what are some of the ethical conflict issues that agents face, especially commercial agents?
It's not that I pick on commercial agents, but I just find that sometimes commercial agents like to dance a little bit too close to the lines because, frankly, you work a long time on one transaction. Residential agents, 60 days, maybe 90 days, they're done with that client, move on. You guys are hanging out with your clients for 8 months, 12 months. It's a long process. And so you kind of do what you need to do to get the deal done. But as a part of that, I think that what I find is that my commercial agents tend to get a worser rap. I mean, I think that you tend to be looked at as more of a used car salesman than the residential agents get looked at. You can correct me if I'm wrong, but I think that that's kind of where you kind of slide a little bit further down the rung. So specifically, the issue that I find is breach of fiduciary duty is a big problem. So there's 2 issues that come up. The first one is that you are dual agents in a transaction, and you forget that being a fiduciary to your client means that everything you do has to be in the best interest of your client. So if you are a dual agent, that means that everything you do has to be in the interest of both clients. So when one client doesn't want to perform, and the other client says, issue a notice to perform, Once you issue a notice to perform against your own client, you are breaching your fiduciary duty against your own client. I'm not sure that all of you heard that, because I didn't hear enough of a, When you represent the seller and the buyer, and your seller says, issue a notice to perform to the buyer because they're not doing what they're supposed to do, most of the time when you issue a notice to perform against your own client, you are breaching your fiduciary duty against your client.
If you refuse to issue the notice of perform, have you breached your duty?
To the other one, yes.
So that is a problem, which is why when you are a dual agent, you explain to both sides, this is what dual agency means. And you better have had that conversation before you agree to be a dual agent. And your seller then will be aware that if there comes a time when one's going this way and one's going that way, that you will have to stop and say, I can move no further. I will have to stop. So then you have to say to the seller, look, we had a conversation earlier. If the buyer is going to not perform and you want to issue a notice to perform, I am not going to be able to issue that. You'll have to do it on your own or get counsel to do it for you. Now, if the buyer says, issue me a notice to perform and I'll get out, I don't care, then that's not going to be breaching because really they're both moving the same direction. The buyer just wants the seller to force him out. And that's okay, but that's not typically the situation. Typically the buyer's like, no, 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 I want to buy. He just is being stubborn. And the seller says, no, 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 I want him out. Get rid of him. That's going to create an ethical conflict for you. And it's hard because you're stuck in the middle and they both say, well, now you're not doing what I want you to do. But you know what? Escrow falls into that all the time, right? So you just make sure you have to have the conversation ahead of time about here's what being a dual agent means, and it may come to a point where I can't move forward. Because trust me, if you move forward, you will be sued. I've had agents sued on this exact issue, and it gets expensive because you know what you lose? When they decide they want to close, you won't get paid because you'll have been donating your entire commission, and you'll get to pay everybody's attorney's fees for moving forward. So you're not just out of your commission, you're out of pocket. And that's a really bad place to be. The other problem that I see that falls particularly into the commercial bailiwick for ethical issues is representing the wrong people. So there are 4 parts to a transaction: buyer, buyer's agent, seller's agent, and seller. You can never be more than 2 of those that are connected. 2. If you're more than 2, you will be breaching a fiduciary duty to somebody. It's just, you have to be. Because if you're the seller and the listing agent and represent the buyer, how can you possibly represent a buyer and be the seller? You just can't do that. Or the best one I see is you're the seller, you hire an agent, or maybe you're part of an LLC, and so the majority owner hires an agent, but you're a minority owner, and then you represent the buyer. So you're the buyer's agent and you're the seller. How can you possibly represent that buyer in their best interest when you're a seller? You just can't. But the one I see the best of is you have a listing and it's sitting on the market and you know it's not a dog, so why is it still there 22 days later, 122 days later, 222 days later? You don't understand. It's a great deal. So you decide you're going to buy it. So you have the listing, you're going to be the buyer's agent, and you're going to buy it. I'm stunned. I don't even know what to do with you at that point. So the only way that you can actually get around that one is to resign from the listing and make the seller get another agent. Because then you can buy it. Because you no longer represent the seller. There's no fiduciary duty now to the seller. The new agent can be your best friend. I don't care. But they have to have their own consultation with somebody else so that you aren't the agent anymore. Then there's no way you could be breaching your fiduciary duty to the seller because you don't have a duty to the seller anymore. But if you remain the listing agent, or you just resign and they're just hanging out on their own, remember, actions create agency, not forms. I guarantee that seller still thinks you're their agent. How can you buy a property that's looking for yourself and your interests while you're still trying to do the seller's best interest? It's just not possible. When you buy that property, you might as well put a chunk to the side, because the time is going to come when the seller will go to a dinner party and explain to Jim or Bill, sitting there, about what a great deal they had, and Jim or Bill will say, I'm sorry, what happened? No, you could have gotten a better price for that. And then they'll figure out how the better price would have been gotten, and then pretty soon the seller sues you, and then you no longer have the property because they've sued you for everything you have, and they've taken the property back, and it just goes downhill from there. So don't do that. There's 4 parts. Remember, you can only be 2, and only 2 that are connected. The agents are in the middle, and the clients are on the outside. So 2 that are connected. So you can be dual agency, no problem. You can be seller and listing agent. You can be buyer and listing agent, but that's it. Okay?
And on a personal note, from practical experience, I really think that dual agency is an inherent conflict of interest, and it just causes more problems. And I have, in my career, lots of cases where the dual agency comes into play, causes more problems. I know, as someone earning a commission, you'd really like to get both sides, and it seems like easy money, but in the long run, it's not safe.
I mean, I cannot agree with that more. In our profession, we call that malpractice.
Yeah.
So we're not allowed by our ethics rules to do that. In your profession, it's not called that, but I will tell you, in our company, 75 to 90% of our transactions that go into any kind of a dispute are dual agency transactions. So, yeah, I mean, I hear you all. You don't think about that, but the amount of conflicts that you approach in a dual agency transaction are sometimes so insurmountable that you just hide your head in the sand and you hope it's going to go away, when really you should just be praying every night that you're not going to be sued. And then the worst part is you reduce your commission on a dual agency transaction. I mean, I think you should increase your commission, because the amount of money you're going to have to pay out because somebody is going to get their feelings hurt is really, a problem. So I completely agree, and my agents all know I am not a fan of dual agency. I have a couple of agents here, and, I think refer it out, get a 25% referral fee, keep your 2.5 plus your 0.25%. You're almost at the 4% then, and you have half the liability instead of the whole liability. So.
Thank you, Holly. I'll come back. I'll give everybody a chance. Jim, so how do I get my tenants to do what they're supposed to do?
Again, Landlord 101. Short answer, enforce your contract. Now, the question is, do you know how to do that? You should. If you don't know how to enforce your contract, again, this is basic, how to be a landlord, basic running this business. I tell my clients, to be an effective landlord, a pretty good landlord, you only need, I think, 8 documents. One of them's not a legal document, the application, and know how to use them. And good news, they're all in form. So it's just fill in the blank. This is, being a landlord, residential landlord, is really not all that complex. You know your contract like the back of your hand. You read it, you understand it. If you don't, you call me or call your lawyer and say, what's this mean? Okay? So you're thoroughly familiar. It's your rules, your property. If you don't know the contract, then how are you going to enforce it? For every problem, almost every problem, with a good contract, if you have a good contract, CAR, up to date, AOA, AGLA, Westside Rentals is okay, I guess. They're all good, okay? A really good contract will cover, golly, about 98% of every single possible problem that tenant can cause you. So if there's a problem, it's in your contract. So if the tenant's not doing something they're supposed to do, there's a breach of contract somewhere. If they're not doing something they're supposed to do, like pay rent, it's in your contract. And so you enforce your contract. And you have the proper tools, I call them tools of the business. Rental application, the lease is by far and away the most important one. The lease is everything. 3-day notice to pay rent or quit, 3-day notice to perform or quit, 30-day notice, 60-day notice if it's not rent control, 24-hour notice to landlord's intent to enter, security deposit accounting. That's about it. It's not that hard. And you've got all the tools to be a landlord. Now, do you know how to use them? Do you know how to fill them out? Do you know how to serve them? Maybe yes, maybe no. But this is basic Landlord 101. I tell all my landlords, especially the mom and pops, get out your contract and read it. Almost all of them, I know for a fact, have not bothered to take the time to even give it once through. And I'm saying, where does your money come from? Let me ask you, where does the money come from? Where does the rent come from? I mean, you're going to say the tenants, yeah. Well, true. Why does the tenant pay you rent? Because they have to? Because they want to? Heck no, they don't want to. It comes from the contract. The contractual legal obligation that says, no, you must, under this contract. So the contract, the rental agreement, lease or month to month, is absolutely critical that it's done right. Creating the tenancy at the beginning, creating it the right way with the right contract, and getting everything you want and everything you need as a landlord or property manager is absolutely critical. Almost about, I guess about 7 out of 10 cases that I do, whether they're evictions or not, didn't have to happen, are self-inflicted. And I feel horrible telling my clients, you did this. You did this to yourself, because you just didn't read your contract or have a basic, rudimentary understanding of this stuff. And okay, now we'll fix it, but you shouldn't have to fix it. Okay, there's certain things that that you're going to have to do evictions on. If tenant's not paying the rent, you didn't cause that. Stuff happens. But about 7 out of 10 of my cases, a good 70% of my practice, didn't need to happen. It's self-inflicted. The landlord or the property manager didn't know what they were doing, made a mistake, and now we're in litigation, and it's going to cost a whole lot of money. So if you have I tell my landlords and property managers, read the contract. It's like a primer on how to be a landlord, like a Cliff's Notes. So spend a half an hour studying it. It's everything. And you will have some questions. And what you don't understand, you call a lawyer. What's this mean? Do I need to know what this particular, there's no waiver clause means at this particular time? Probably not. But at some point, you'll love to have it. So I think that answers that question.
I
Thank you,
want to
Jim.
just jump in real quick. I totally agree with Jim that the lease is the most important agreement, and there are lots of good forms out there like the car and so on and so forth. But a lot of people are downloading what they think is a good contract off the internet. Oh, I'll go on the internet. I'll
2
get a good
pages.
form. And
Every day.
It causes more trouble. It just gets everybody in a mess. A lot of times those provisions are not California law. It's just a mess. So if you see people, oh, I'll get one off the internet, don't do it. Get a reputable form and use that. Don't do things off the internet. It's just not what you think it is.
Exactly. I strongly, that's such a good point. And I see it almost 2-3 times a week. And I said, well, this might be good for Nebraska in 1985, but it's certainly not good for rent-controlled Los Angeles, California in 2016. I tell my clients, whenever you're going to use a legal form, even if you have a good one, okay, if it's more than about 2 or 3 years old, it's probably out of date. That's why CAR, which I really like, has revision at the top and the revision at the bottom of the first page. I mean, it's hitting you twice. How old is this document? Because it will go out of date. Laws change. New laws are added. Laws are deleted. I tell them, you must always have the most valid, up-to-date California form. How do you know if it's valid, up-to-date in California? Well, you look at revision. If it's from CAR or AOA, probably good chance, but maybe they didn't pull down the old version, just threw the new version up, and you downloaded the old version. Okay, so it's real. I see it all the time, and I have so many clients come to me who've tried it themselves or with a lawyer. Had one with a lawyer yesterday. Didn't catch this thing. It's not good. It says $300 to pay rent or quit. Yeah, but it doesn't satisfy California law, and they got blown out of the water, and now they need to fix it. And it's tragic. So there's so much information on the internet, and it's like. For the medical profession, WebMD, there's some good information there, but you might want to go to the doctor instead of self-treating.
Thanks. Bill, next case.
All right.
Please.
So there was a confirmation in a case called Coker versus J.P. Morgan Chase Banks that the anti-deficiency laws that protect homeowners in a foreclosure setting, and so that the bank can only take away the property and foreclose the homeowner and borrower out, also applies to short sales where the bank is only allowed to take the negotiated amount and then they cannot go after the homeowner or the borrower for additional money since they accepted a short sale. That's it for them. That's all the bank gets, and they can't keep coming after that borrower and trying to get additional monies or try to negotiate additional monies, and that that case, I think, is just something that you should all know and be able to advise your clients that if they can do a short sale, then the bank is done and can't come after them any longer for more money.
This is the one where they used to say, yeah, we'll agree to the short sale, but you got to pay us $5,000, right?
Or 20, or you know,
yeah,
whatever
and
that
we'll write a
number is.
note, and you can
Yeah.
pay this off over the next
Right.
couple of years.
We'll take,
Okay.
you know, we'll take a couple thousand a month and so forth. But those days are gone. We have a nice firm case that says that the anti-deficiency only taking the property back and can't go after the individual borrower. Yes.
Does that apply on a commercial or industrial property?
You know, that's a real good question. I read the case. It didn't say anything about commercial. So I would say no generally because commercial property has lots more exclusions and the anti-deficiency doesn't really apply to commercial usually. So probably not. Just residential.
Thank you, Bill. So back to Holly. So how can an agent create a lawsuit-proof file?
Not practice. No. So I think there's a couple of things. First of all, you have to know who the seller is. This seems to be a problem lately where agents go to take a listing and whoever is there is the person that signs the listing and then they go market it and then they get a buyer and then the preliminary title report comes out and the person who signed the listing and the purchase agreement doesn't actually own the property. So it can come up in a couple of ways. One, the names actually don't match and you just have a scammer. But two, it could be that the person who's signing isn't an authorized signer for whomever owns the property. So we've had it come up in a couple of ways where it was an LLC and the LLC required all of the members to sign, but only one person had signed saying, I'm the authorized person. And you could go into the arguments about, well, the buyer still gets to buy it because the LLC presented that he was the right person, and then all the members can have a case against the member who signed and didn't have authority. But it just creates a mess. And it's much better to know right up front who has the authority to sign for this LLC. The one that we've had a lawsuit about and that we just recently had again this last week with a commercial agent was a trust issue where the trustee was not the person that was signing. So it was clear when you pulled the grant deed, because that's how you know who owns it, right? The grant deed will tell you the most recent up-to-date grant deed, just like the lease, the most recent up-to-date grant deed is the one that will tell you who owns the property. Now, if the person comes to you and says, you know, I'm Holly Thomas, but the grant deed says it's supposed to be Jim Thompson, well, then you got to figure out, why are you saying you're the trustee, but it's not Jim anymore? Well, maybe Jim has passed, and I now have the documents that show that I take over for the trust, and that's perfectly valid. But otherwise, you better be asking, how come you're not talking to Jim, and why are you talking to Holly? Because we had an issue where both directions. One, the parents came to the agent, and the agent pulled a little tiny one-page report that said that it was a trust. And so he said, you have a trust. And they said, yep, it's our trust. And it was named Mr. and Mrs. something trust. And he said, yep, that's you, Mr. and Mrs. whatever. And he said, and you're the signers on the trust. Yep, we're the trustees.
Oh, maybe not.
Went into contract, got the preliminary title report. No, the daughter is the trustee. And she said, we are going to have way too many tax consequences. We're not going to sell this property. What are you, crazy? So they backed out, and they could because the trust wasn't on the hook. And the buyer was gracious enough that he allowed our agents to pay for all of his fees, $2,200, because he'd already done his appraisal, he'd already done his property inspection, he'd already done his mold inspection, he'd already moved through the process. So our agents got to pay $2,200 to allow this buyer to back out, cancel the transaction, and move on to the next deal. That's an expensive mistake when you can just call your title rep and say, hey, can I have the grant deed? It costs you an hour. It's a lot cheaper than $2,200. We had a lawsuit recently that we settled in the 6-digit range with a same kind of a situation, but the mom had become incapacitated, but our agent didn't know that, and that was fine. And she had been removed as the trustee, and it was clear on the grant deed that she was no longer the trustee, and the agent never pulled the deed, so didn't know. And the buyers fought it all the way through, lost in arbitration. Then they came back to us and said, well, you get to pay for everything. And we said, well, yes, we will, because We were the problem. We weren't that gracious about it, but eventually we did have to pay. So, you got to be really careful and understand who is your seller. And if you're on the buyer side, pull the grantee. You need to make sure your buyer's buying from the right party. It's not just the listing agent's job, right? Because if you represent one of these buyers, they're going to say to you, how come you didn't know? Don't you have access to this stuff? Another problem is not getting all the documents you need for your file. And I'm not talking about, your brokers making you check the box and you got everything in the checklist and how can they make me get this form. I mean from a legal perspective. Every file in the state of California, when there's a transaction on a piece of real property, requires an NHD report. And if anybody tells you different, they have no idea what they're doing in California. Every real estate transaction in California requires an NHD report. And if you don't have one, your client doesn't have all the information about their property. Are they in a severe fire area? Do they have liquefaction? Are there environmental concerns? All the things that you guys just go, here's the report. Open it up and look at it. There's kind of fascinating information in there. If you want a little night reading, you can go through that and check it out. But, it actually gives your client some information about the property, and we just sort of brush over it. But, those things, disclosure, commercial agents are terrible at disclosure. You think because it's not a 1-to-4 that you don't have to disclose anything. And let me tell you differently. The law says there's these forms you have to fill out when you're residential. But then there's this disclosure area that says you have to disclose everything you know that's materially going to affect the value or desirability of the property. So if you as an agent or the seller know anything that fits over here on a commercial deal, you have to disclose it. The tenant has paid late previously, even though they're currently paying on time. I think that's a material issue, and I think the buyer would want to know that. That affects the value or desirability of the property. We had a huge mold problem in the back northwest corner apartments because we had a huge water leak. It's been fixed for 2 years and we haven't had any problems. You better disclose that. Because guess what? When El Nino really comes next year, please, 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 you don't know what's going to happen in that back northwest corner. And if it starts to leak and they call and say, so we happened to call, because it always works this way, so we called a roofer and a plumber and they said they fixed this for you 2 years ago. And you didn't disclose it, you got lots of damages, you and your seller. But if they call and the roofer and plumber go, yeah, we fixed this 2 years ago, and this buyer can say, yeah, we know, then there's no damages. So if your client fits into this category, you're not 1-to-4, so you don't have all those paperwork issues, but you have disclosure issues, and how do you do it? Any way you want, as long as it's in writing. You can do an SPQ. Just because you don't have to have the form doesn't mean you can't use the form. And the SPQ, I think, is a great form for every seller to look at. Whether they're required to deliver it or not, I think it's a phenomenal form. It makes people stop and think about what has happened with my property. I've owned it for 19 years. There's no way that I can just start sitting there and thinking about my property. But when I have prompts on these questions, I can go, oh, yeah, that's right. We had some wind damage. We had a tenant. We had. And there, before you know it, now you're disclosing the things you're required by law to disclose. You can do it in a Word document. We've had clients that gave us like 6 pages of all the things they did, right? They can do it in a long email. Send it to you, you send it on. Just delete their contact information, right? So it doesn't matter how they do it as long as they do it. And remember that your seller, the more they disclose, the more they're shifting the liability to the other side. I think sellers feel like, and agents mistakenly think, that if we don't disclose, we're not creating liability. But if we do disclose, we create liability. And it's the opposite. When you disclose, you push the disclosure to the other side, and the liability goes with it. And the last thing I want to say to you, and you're going to laugh at me, is that you need to keep notes about what you do with your client. and you say, I don't have time for that. But trust me, if you have time to not be sued, you have time to do this, okay? I keep a communication log. I don't know about you guys, but I keep a communication log and have been for the 15 years that I've been a lawyer. And if you call my office, you will hear my typing in the background as I am typing what time you called me, who you are, where you're from, and what is the issue that we're talking about. And I don't take, paragraphs. It's a basic, simple, here's the issue, here's the resolution we had. And if you keep records on your phone calls and your meetings with your clients about substantial things, you don't have to say, called the client to tell him there was an inspection scheduled. But when you have the inspection and you talk with your client about the inspection, you should take notes on that. Because when you come back in 5 years and there's a problem and you look at your notes and the client says, well, you didn't tell me about the leak in the back northwest quadrant of the units, you can say, actually, we had this meeting and we talked about it and I delivered this to you in writing and we had this long conversation and here's what you said. And those notes will be admissible against the client. Not that we want to go against our client, but if you constantly keep those notes and you're consistent about it, I'm not a litigator, but I'm sure these two will agree with me, you will be able to show the court, these are my notes, and you won't be sitting there saying, I don't remember, I don't remember, I don't remember, because you'll have notes to remember. So communication logs of some sort, documentation in your file, and know who the client needs to be. And that will go a long way to keeping you out. And don't do dual agency. That will go a long way to keeping you out of a lawsuit.
All right, thank you, Holly. Jim, back to you. So what's the best method of collecting rent from my tenants?
Okay.
Clawed out of them.
There's, I think I talked previously about, about 80% of what real estate landlord-tenant is, there's a law on how to do it, and lots of that's in your contract. Another 17%, 17%, there's a manager rule, real estate rule, laws or statutes, ordinance enacted by the government, and landlord shall, and you better do it. If you don't follow the law, you're breaking the law. Rules are, I define them as what professional property managers and property owners, landlords have learned. This is how we do this business, because we have all these other factual problems if we don't follow this rule. It's not a law, it's a rule. Then there's this management style, okay? Management style, about 3%. So that's not much. 3 decisions out of 100, you get to do them the way you want. And collecting rent in the normal course is one of those things, how you actually go about getting the money into your hands. I have a lot of landlords going over and banging on doors. And I'm going, well, can you? There's no law that says you can't. Is there a real estate rule you can't go banging on the doors asking for your rent? No, and I understand as a landlord myself, man, I need to get that money. I need to pay my bills. But it's really inefficient, one. Half the time the tenants aren't home, and when they are home, you're harassing me, I don't have the money, so you're wasting your time, okay? So collecting it personally, I don't recommend. Is it lawful to have it direct deposit? This is a rampant problem. Laws changed about 2 or 3 years ago. Actually, more than that. When you get to the 3-day notice and the tenant's not paying, the law says you can tell the tenant to pay it, but only these 3 ways to get it to you. 1, they can bring it to you or your agent, but you got to give them the name, address, phone number, and the hours. That person will be there to collect the rent. 2, you can have them mail it. Or 3, you can direct deposit. I've had more than a couple brokers do the direct deposit route, either in the normal course, and they set up their tenancy, or when they get to the 3-day notice part. Okay? Think about that. I'm giving my personal banking information routing number to a tenant. And that's the most obvious part. There's a problem there. Identity theft, well, okay, I'll run the risk for convenience. Really? Okay, fine, that's your shot to call. But more importantly, I had a realtor who helped me buy one of my properties call me and said she was doing direct deposit, and she didn't get the concept. I said, well, it's not a good idea because identity theft. She said, yeah, okay. I said, but it's much bigger. I said, what's the problem here? And she goes, well, they got 6 people living in there. I said, okay, the result is you do a 3-day notice to perform or quit. You've got only so many people non-rent control in this contract, and you've got 10 people living in there. Get back down to the 4 that's in your contract. I said, now, they've got direct deposit with their rent. Think about this. And all of a sudden she gasps, because now she catches it. And there should be a gasp from you. She goes, oh my God. I said, yeah, all they got to do for whatever the problem is, you have a 3-day notice them to fix it, right? All they have to do is wait for the 3rd day in their underwear at 10 o'clock at night and bang 50 cents into your account. And then the notice is gone. And you better know about it, because if you start the lawsuit and they didn't pay me, they didn't comply, whatever it is, they didn't get rid of the dog, whatever the problem is, and they go to court, they go, yeah, I got the notice, and here's my deposit, 50 cents into your account. The law is if you take any rent during the notice or after the expiration of the notice is gone. And she kind of got the concept. Like, so by direct deposit, you've taken all the control and the ability to enforce your contract away. She goes, what do I do? I said, geez, I don't know. I've shut down the account, maybe. So direct deposit, this is where the legislature didn't think this all the way through. Direct deposit's convenient. It's modern technology. Hey, great. I don't have to process checks and wait for it or go to my P.O. box or whatever. I don't have to run to the bank. It just shows up on my bank. It's on my ledger. Another problem with direct deposit, now there's some banks that I think will give you some kind of means to show who paid it. But most banks won't. It just shows up as a deposit. How do you know that money came from that tenant? I don't know. The best way to answer the question is, I think it's old school. Now, you may disagree with me, and if you do, come up to me afterwards and tell me how cool it is, how it works for you. There might be some kind of way to do it that I haven't figured out yet. Old school way, have them mail it, have the tenants mail it to a P.O. box. P.O. box, I think, are beautiful things for landlords and property managers. It provides anonymity, security, puts the burden of proof and delivery on the tenant, not on you. You're not wasting your time. You're not harassing them. It either shows up in the P.O. box or it doesn't. And most importantly, you have a U.S. postmark on that envelope to show when they put it in the mail. I had a tenant, wonderful tenant, sweet lady, always paid her rent on time. One time she paid really late. I mean, I'm not going to hold her feet to the fire. She paid on the 7th. I got on the 7th. I'm like, don't want to do a notice to perform or quit on this. Is it really worth it? She's nice. She always pays. She's a sweet lady. Well, if I let her do it, she's probably going to keep doing it. Let me just do the notice. I'm not going to enforce it, but just let me give her the notice. 3-day notice, perform or quit, late fee. Okay? Do it, serve it, forget about it. A couple days later, I get a phone call, and I recognize her voice. And she goes, Mr. Thompson, yes, hi, how are you? And I'm reaching for my book because I don't know what she's calling about, for my records. And I go, oh, now I know she's talking about the late fee. And she goes, I know I paid the late fee. I know I paid on time, because she always had. And she wasn't trying to lie to me, wasn't trying to cheat me. She honestly believed that she had paid on time, because she always had. Well, she didn't. And she says, I know I paid you on time. I said, you sure? She goes, well, let me be real clear. I know I purchased it on the 1st, and I mailed it on the 1st, so you must have got it by the 3rd, which is the late fee kicks in. So she knew the contract. I'm like, okay. I said, okay, and you're sure? She said, I'm positive. I said, okay, well, let me say this. The money order I'm looking at, copy of the money order, says it's purchased on the 5th. And I said, the U.S. postmark on the envelope that I have, right in my hand, shows the 7th. I'm telling you in my 3-day notice that I got it on the 8th. So who's mistaken, me, the post office, and the money order, or you? And there was that beautiful silence. So just pay the late fee and you'll be fine. And that was it. It takes longer to say it than what it is. But that postmark, she just like, he's got me. Oh, I guess I'm wrong. And she wasn't trying to cheat me. She was honestly believes it. So mailing, I think, is the best way. But it's one of those management style things. There's no law or rule on it. You can go by and collect it. You can direct deposit, but I've told you why it's not a good idea, and with the risk you're taking, huge. I think mailing is the best way. I'll wait a day or so for anonymity, safety, postmark, documentation, paperwork. That's what I do.
Can I just also add that direct deposit, depending on how it's done, they can dispute it and pull it back.
Yeah.
All right. Bill, back to you.
Okay. Well, our federal government and the Department of Fair Housing has basically had a couple big cases regarding children in apartments, and the Department of Fair Housing has decided that they're going to try to protect families and allow families to live in apartments even if the landlord and the owner really isn't too keen on the idea. In a 2-bedroom apartment, it was ruled that a family, husband and wife, and 3 children should be allowed in that 2-bedroom apartment. So 5 people in a 2-bedroom, and the apartment was 1,250 square feet, which is pretty good sized. Didn't say anything about the sex of the children or anything like that, but the housing department came against the landlord and fined them quite significantly for denying this family of 5 the right to live in a 2-bedroom apartment. They also came out on any kind of restrictions about no play and rules at the apartment building about letting children play in common areas. And if an apartment owner, landlord, tries to regulate children, where they can play, when they can play, and so on and so forth, the landlord got in trouble and was fined for that as well. So, you know, the instances are, you know, well, we have a special area over here. This is the only place kids can play, but over there they can't, and it's not going to work. And the same with limiting it, like, oh, hours for play is between 4 in the afternoon to 6, and then they have to be in and can't, you know, do anything after that. That's not going to work either. And just be real careful with the number of people in the unit, and knowing that the family is very, you know, is getting more and more protected against the landlord and the owner of the property as to how they can, you know, dictate who moves in and who doesn't.
I think that this is one of the most shocking things for agents, is that they don't understand that you can't limit a bedroom to 2 people.
Right. Yeah, and
And-
it's the perfect example. And that's a big unit, 1250, and they still said, oh, no, you know, the landlord's wrong and the tenants are right. So it is something that, you know, the law is going that direction, you know, just like it was going that direction with, you know, people with mental health needs to have, you know, pets and so forth. It's going that way.
Protecting them, yeah.
On that issue of occupancy, a HUD, the general, you know, HUD, their standard is, you know, 2 per bedroom plus 1. That's why 5 for a 2-bedroom, regardless of size. City of LA, they use a square footage formula, and it's really complex. A big problem, and it continues to grow, is, you know, too many people in a unit, or unauthorized occupants, okay? Well, it depends on if it's rent controlled and what city and all that stuff. If it's non-rent controlled in non-LA, the HUD standard applies 2 plus 1 for the common area. Well, where are they sleeping? Well, you don't care, okay? But LA City, square footage, and there's a formula, and it's fire code. Fire code. I have an eviction going right now for too many people in it, in LA City, in rent control. And they think we're trying to evict them to raise the rent. Yeah, maybe we are. But there's too many people in there. And it's a fire code violation of law, not the HUD standard. So it depends on where you are. On the issue of companion animals, service animals, comfort animals, whatever they're called, that's been going on for a couple, 2, 3, 4 years. Had a client come to me and, you know, she has 3 dogs, and the contract says no dogs. He said, I want to evict her for get rid of the pets. And I said, yeah, you get a feel for certain tenants and where they live and all this stuff. I said, no, we're not going to evict you for the dog, but the contract says no pets. I said, yeah, I got it. And she's got 3 dogs, and I can prove it. I said, yeah, I got that. I said, but what we're going to do is evict them or to do a 3 hours perform a quit for the damage, for the uncleanliness. Is there dogs that I have nothing against dogs or animals as a landlord. No, it's what the animals do by their very nature. They have to have bodily functions. Dogs bark, scratch, chew, growl, protect, you know, and it's what they do to the property. And how they disturb the other tenants is why we don't want them. That's why all the form contracts say no pets. But we evicted them for what the pets did. And the tenant came into court, and sure as heck, she went out and got a doctor that says I'm disabled, or I've been treating this person, some I won't say what city it was in, some schlock doctor, let me put it that way, and for emotional trauma, and in my medical opinion, she needs 3 dogs as her comfort animal. The doctor wrote this, and she's disabled. And I saw that, and she came into court with this. And I said, well, we didn't go at it for the dog, so I don't care. It's the damage, totally different issue. So we started the case, and she says, I'm disabled. He's evicting me because I got dogs, and here's my thing, Judge. And I go, okay, Judge, it's not the issue here. But let's determine, because I knew she was going to go to fair housing.
But let's have fun.
Yeah, let's have, exactly. I said, no, and I brought out the definition of disability in California and all this stuff. And I said, now, does this meet the definition of disability under California law? And I wanted the judge to make a finding, because I knew this wasn't going to be over. We're going to evict her, but she's going to come back with HUD, you know, and fair housing and all this stuff. And she said, I said, is it rational that any doctor can say that she needs 3 dogs for her personal comfort? 3. The judge says no. I said, so you're making a ruling that she's not disabled? She says, yes. Good. Can you write that down, Judge, in the notes, in your ruling? And then we went back to the issue about the damage. Well, we had pictures of torn doors and chewed up stuff and, urine stains on the yard and unpicked up dog feces in the backyard. She's a slob, 3 dogs. They're gonna make a mess. And the house stunk to high heaven. Well, you can't bring in smell to the court, but she could see it. And we won the case. We evicted the tenants. They went to Long Beach Fair Housing, LA Fair Housing, State Fair Housing, Federal Fair Housing. And I had a head of Fair Housing State call me up. And I said, she goes, she's disabled. I said, well, that's your opinion. Well, we're going to turn over commissions. Go ahead. I said, what's the commission going to do? I said, you get the U.S. attorney. I said, have the U.S. attorney call me right now. I've already got a judge that says she's not disabled. Okay? But we dealt with that issue. So you don't want to deal with that. The companion animals, pet animals, I'm disabled. No. Just find something else. What are the dogs doing? You don't want to have the dogs there, not because they're dogs, because of what the damage they're doing, the property disturbance or whatever else.
Great. So back to Holly. Talk about procuring cause. How do agents enforce procuring cause when a buyer goes directly to the seller?
So don't shoot the messenger. But there is no real procuring cause in California and hasn't been for some time now. So if you want to protect the relationship with your client, you need to do that contractually, because if you don't do that and your buyer and seller have met at the property and on the side exchanged information, and then the buyer says, yeah, I decided not to buy it, and then you find out in 4 weeks that they bought it through the seller directly, you have nothing. So you need to either have a buyer representation agreement with your buyer. How many of you use that form? That's pretty pathetic. So the buyer representation agreement is a great form. If you don't fill out a percentage down at the bottom of the page for how much they'll pay you, you have nothing. So you have to fill something out in there. You could fill it out for a short time period. It doesn't have to be 6 months if your buyer's freaking out. Fill it in for 2 weeks. So you got to have a percentage in there, because if they go around your back and you didn't fill anything in, they owe you nothing. Okay, so you got to have a percentage. Or you do a single party compensation agreement with the seller. For this particular buyer that I'm bringing to you, if he or she or they buy it, you'll pay me. Period. End of story. Now if the buyer goes around you, you don't care, because you've got a document that you're going to get paid. And hey, you didn't have to do any work. One of the few times when you get to work, not work at all, and you get paid anyway. So if you don't protect yourselves with documentation, there is not going to be some safety net at the end that says, well, but you brought the buyer to the property. Everybody's going to say, good for you, and then walk away. The same thing if you have a buyer and you've shown them a property, and then they call their cousin, and they write the offer with their cousin, or their best friend, or their neighbor, or the guy who door knocked them yesterday, right? You have nothing against that agent. That agent was just being a great agent and convinced them to not be loyal to you, unless you have something in writing. Okay, now you're not allowed to interfere with an agency relationship. So when you talk to somebody, you have to ask them, do you have an agent? And if they say yes, you need to ask them, what do you have in writing? Because you need to know what is that contractual relationship that they have, because just because they're contractually obligated with one agent on this property doesn't mean you can't talk to them about their other property. Right? They have a listing on their primary home. You can still talk to them about getting their 8-plex listed. So you need to know what is that relationship exactly. So you can't interfere in that. But if they say, I have an agent, but I'm not really happy with them, I've only known them for 3 days, they were referral to me, and I'm thinking I'd like to change agents, there you go. There's your window. Walk on in. Have a conversation. And then you tie them down and you close the deal. There's no procuring cause. That being said, you have a reputation. And if you don't protect your reputation by not screwing over your fellow agents, then you will be the one in the corner. And nobody will work with you. Okay? So while there is no procuring cause, you don't want to be the guy or girl that's known as the one who always comes and steals and poaches. Because once you have that reputation, you can't shed it. We all know who those agents are.
Is there the single-party compensation agreement? Does that form exist in either CAR?
It is a CAR form. It's an SP form. So there's actually 3 different ways that you can get paid. There's a listing agreement. There's a couple of them, but the listing agreement, single-party compensation agreement, or a plain old commission agreement. So any of those will work to protect you, and then the buyer representation agreement if you're doing it on the buy side. And actually, a single-party compensation agreement can be signed by the buyer, and same with the commission agreement. The buyer can agree to pay it, and depending on the transaction, the buyer may be the one that agrees to do that.
Thank you, Holly. Back to Jim. So I just closed an escrow on a rent control building. I didn't get any written leases, contracts, or rent rolls. And my friends are telling me I should have gotten some Estoppel certificate. What's that?
Okay. You all know what Estoppel certificates are and the purpose of them is, right? I hope so. And if not, I'm going to give you my definition, and your definition might be a little bit different. I tell my clients that a Estoppel certificate is an update, a modernization of the terms in the contract from the tenant's perspective. Not the whole contract, but, who's there, how much they're paying currently in the rent. People move in and move out sometimes. The rent should go up, so those terms have changed from the original. And, a rent due date and actually, CAR doesn't have a rent due date on. I wish it did. That's a flaw in that system, that form. But it just updates the contract from the buyer's perspective, from the tenant's perspective. So it stops the tenant from denying that, yes, I am the tenant. Yes, these are the people that live here. And yes, this is how much I pay for rent. So in case the seller is saying, well, here's the rent roll, and here's what they're paying in rent, and there's really good, and you find out that that's not the tenant's agreement or what they've been paying, you kind of want to know that. In rent control, this is a problem that I've had so many times, and it's absolutely tragic. And they're always looking to go right back on you, the broker, for not telling them this, not getting the Estoppel certificates. And I've had so many clients do this, close on a rent control property, no estoppels, no contracts. Here's what I tell them. Sorry, rent control with no contract equals disaster. Make a plaque, put it over your business. That's what you've got. You've got nothing. You've owned the property. You've got all the obligations and liabilities, but you have absolutely no control over the property, okay, without the contract. And that's in rent control. It's common sense that you want leases for everybody, no matter where it is. But in rent control, it's absolutely critical. And if you don't have contracts, at the very least, get the Estoppel certificate, so at least you've got something signed by the tenant saying, yeah, that's me. I live in this apartment. This is how much rent I pay. And here's who lives here. So you got at least 5 of the pretty much essential elements you need to know, at least start. And it's an absolute nightmare for if you buy a rent control property with no estoppels and no contracts. You've got nothing. How much rent, how do you know who's there? One, how do you know how much the rent is? Because you got a rent roll from the landlord? No. How do you know when the rent is due? There is no late, unless they're a full month late. You can go ask the tenant. I've seen this. They don't know. I said, go ask the tenant who they are and how much their rent is. They give them the name, and they go, this landlord doesn't know how much, I'm going to pick, for this 2-bedroom, I'm going to pick $650. It's rent control, and they just pick it. That's all you got. I mean, and that's just the tip of the iceberg. Had a sweet widow lady call me up. Her husband ran the whole show, and he passed. He had a rent control property, and he was the landlord, and the wife is just the wife, sweet lady. And she calls me up in tears. She goes, my husband died, and I've got a tenant who's, just out of control completely, and he's screaming and yelling at me, and she's in tears, poor lady. And he says, I don't have to do an expletive thing except pay my rent anytime during the month, and there's another expletive thing you can do to me. And she goes, is he right? I said, property's rent control? She goes, yeah. She goes, unfortunately, you have a contract? She goes, no. He did everything verbally on a handshake. I said, well, geez. I said, your tenant's right. It's absolute nightmare. That tenant has complete control over the property, and you've got nothing to enforce, nothing. And in rent control, you can't change it. Rent control is different. Rent control is a absolutely, totally different property. The difference between Lomita and Harbor City might as well be on different planets, okay? And I say this to my clients a lot. It's an absolute nightmare. Rent control law says landlord cannot make substantive changes to the contract. Can't make any changes unless they're consistent with the rent control law, which is raise the rent by 3%, and that's about it this year. So you can't force the tenant to make a contract. You can ask them, you can beg them, and they say, no, I don't have to. You can't make me. And they do. They're right. And you have no control over that property. And so that's real clear. And they're going to come back on you. They always say, well, my broker should have told me. And I said, okay. And I'm kind of splitting hairs here. I'm thinking, yeah, that broker should have got you Estoppel certificates at the very least. Should have been real clear with you. You need these contracts. You don't know. You're relying on the real estate professionals. But I bite my tongue. And I say, well, look, all the forms that you signed, the CAR forms, say, broker's not authorized to give legal advice. You should consult an attorney before you close escrow. Did you? No. No, you're consulting me now, but now it's too late. You've bought what you bought. And it's just a nightmare to dig out of these holes for these people. And it's just a tragedy. We were somewhat successful in doing it, but it's like the worst. So never close on a rent control property without having everything you want and everything you need. And you as the realtor better know what your client needs. At the bare minimum, the rent rolls, the rent payment history, all the due diligence stuff, the contracts, and get them a Estoppel certificate. Especially on the buyer's end, man, you definitely want that stuff. Because the contracts could be 10 years old. There's a lot changed since that contract was in, and the seller might not be telling you the truth. What?
Is the buyer obligated contractually, or is the tenant obligated contractually to fill out an Estoppel?
In the CAR contracts, it's in there, yeah. If they don't, if there's no legal obligation for them to fill it out. In rent control, no. Now, if it's not rent control, you go ahead and close. It's not a big deal. I had crummy contracts on a building I bought in Long Beach, crummy one-pagers. I mean, woefully inadequate, might as well have been nothing. And I went to each of my tenants, and here's a new contract, sign it. On my terms, in non-rent control, month-to-month tenancy. And I knew going over, I called them, real nice, we bought the building, and, we're going to come over, and I set up meetings all on a Saturday, and we're going to sign, going to bring in new contracts. I wasn't going to raise the rent. And that's all they care about. You raising the rent on me? No. New contracts. And I knew one of them, probably, at least one, was going to give me grief. And it's not like holier now. This is how we run this business. We expect this stuff. We run our business. The focus is not on the tenant. The focus is on the landlord. It's my business. I run it. You don't get to run me. So I went to the first tenant. Hi, Mr. Thompson, and I got a new contract. I know none of them have them. They always lost them. And so I convinced them that this is for you with new contract. We're not raising your rent with the landlord, so you have a contract with the new landlord. We're not raising your rent. They'll sign it. First one sign it. No problem. Nice relationship started off, and everything's good. Second tenant, same thing. No problem. Glad to have it. They're thrilled to have a contract. And they're not raising the rent. Great. Go to the last tenant finally. And she goes, I'm not signing that. You can't make me. I go, okay, no problem. Go 1, 2, 3, 4. 30-day notice. Back when 30-day notice was lawful for more than a year. Gave her 30-day notice and walked away. She's done. Hold on. Well, what's this? It's a 30-day notice. You're gone in 30 days. It's not a power thing. Don't get me wrong. It's just I'm not letting her run me. I got my own problems. I don't need this. And she goes, well, wait a minute. She turns around. I turn around. I stop walking away. I said, what? She goes, well, I'll sign the contract. I said, look, you don't know me. I just came here. And right off I'm not raising your rent. All I want to do is give you a contract with me, but without raising the rent. And you're giving me grief right off the bat? For what? I said, yeah, you'll sign the contract, and let's go. And so she signed it, and she was the best tenant. She was there for like 8 years and paid on time, wonderful tenant. But she's going to give me grief for, no. So the contract is real important. I mean, you just got to do it. You got to do it the right way.
And it's shocking to me that the Estoppel certificate paragraph in the CAR contract is a checkbox. Mm-hmm. It's not a requirement. So you guys have to remember to check that box every time, because I can't tell you how many times towards the end there's a problem. They call me, what do we do? And I say, well, what is the Estoppel certificate? What Estoppel certificates? I'm like, are you kidding me?
Yeah.
And then I look at the contract and they didn't check the box. So you've got to check the box. By default, you don't get them unless you check the box.
Right. And there's no legal obligation to do it unless you check the box on the CAR form.
But most leases, any good pre-printed form, California, will have a provision that says the tenant has to do an Estoppel certificate, and it gives them a time frame. It's usually 5 days to return the Estoppel certificate. And if they don't return it within the 5 days, then you call up Jim.
Perform or quit.
Yeah.
Bill, Take it away.
I just saw that there was a case that came out recently that also said that a landlord cannot require renter's insurance and evict that tenant if they don't get renter's insurance. And a lot of landlords
Really?
are trying to shift some of the costs and burdens of damages and repairs, as well as theft and so on and so forth, to the tenant by saying, well, get renter's insurance and then you'll be all set, and I'm making you get renter's insurance. Well, case came out that said that a landlord cannot evict if the tenant decides not to get tenant insurance, even if the landlord says you're supposed to.
No, no, you can't. The CAR form has a thing in there that says you're advised, and most contracts, you're advised to get renter's insurance. And that's all you can do. And I have my tenants initial, I used to, I still do, have them initial that, get renter's insurance. And I tell them it's cheap, it's like $10, $11 a month, covers everything in case you get broken into, fire, if it floods upstairs, and a pipe breaks or something like that, and it destroys your big screen TV, I'm not paying for it, okay? And I have one of my clients, I learn all the time from my clients. And one of my clients, we were talking about this very issue, and he says, you know what I do? I go, what? He goes, I buy the renter insurance for him, and I roll it into the rent. And I went, what a great idea. I mean, oh my, $10 a month. And he says, yeah. Then I tell my tenants, look, I bought insurance for you, and your stuff is covered. And so he says, $10 a month, $9.50 is rent, $9.65, $15 a month more. I went, what a great idea. I mean, this guy's thought it through. Yeah, I mean, it stunned me. I've been doing it 27 years ago. Bing, duh,
That's great.
It was great.
Good idea. Yeah.
Roll it on the rent.
Okay, so we'll take audience questions now. Does anyone have a question?
Holly, the SPQ form you recommended, would that apply to 5 to 12 multifamily and/or commercial industrial, please?
So it's not an obligated form. It's not a required, the SPQ seller property questionnaire isn't a required form for 5 and over, but because we have this other disclosure requirement that's not about the forms, but that you have to disclose anything that you know that materially affects the value or desirability of the property, I think the SPQ is a great form to say to your client, look, we don't have to give this form, but you should browse it. And if there's anything that comes to mind, let's answer it. And it goes for anything where there's the TDS and stuff isn't required. You've got probates and REOs, and I still think that you give those forms to your client and say, what do you know? Because it's a great memory marker.
Good morning. I have an ethical question about a listing agency. When you present an offer, you submit an offer on a property, and the listing agent replies to you that they will not be presenting the offer until a week later after open houses. How is that handled, or is that ethical?
Yes, it's ethical if the seller's authorized it.
That's the key.
How can you determine the
You
seller's
can't.
You say to that broker, you say, I really hope that you explain to the seller that you are not cooperating with the commission split, or that you are not willing to go ahead and present an offer until after, because what you're doing is really unfair to your client, the seller. And I kind of say that to them, and then they take it from there.
I mean, there's occasionally situations where the seller's not going to be available, and so, I'll only be available Monday night, blah, 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 and so you're going to present everything then. But most sellers aren't doing that. Most of the time, it's the agent that's making that decision.
Right.
So I think if you confront them a little bit, but if they say, nope, my seller knows, this is what our plan is, there's not much you can do about it. And the more frustrating part is that it's supposed to come on, you're supposed to do presentations on Sunday night, but Sunday morning it goes pending. And there's not
Question?
much you can do about that either.
You guys can go first.
Okay. On the service pets, because you had mentioned, it's for James, that somebody had 3 pets. So is it limited to 1?
Don't know. This judge said.
I mean, because you would think that if it's a service animal,
You would
it's one
think
animal.
one, and this one case that I had where the judge, I wanted her to make a ruling on it, because that had nothing to do with the case, it was about damage. But I wanted her to say, no. In her opinion, in this judge's opinion, nobody needs 3 of them.
Right.
And this doctor, so I don't care if I have a doctor's excuse, and the Fair Housing said, we got a doctor certifying. I don't care what you, the commissioner, Fair Housing, the doctor say. I got a Superior Court judge. The only person who can overrule that judge is the appellate court and God. And so she's not disabled by law when that judge made that ruling. And so it's a case-by-case basis. So that's why when you got a problem dog, even if that's not a service animal at that time, and you do a 3 notice, perform a quick, get rid of the dog, they'll go to a doctor and say, you need a service animal. I'm stressed, I need my dog. Yeah, here it is. And then you go to evict them for the dog, you can't do it. So that's why I said, no, don't evict them for the dog anymore, because it's a rampant, it's a game. And boy, if you don't like this, and I certainly don't as an American, then I encourage you guys to vote and encourage clients to vote. But this is the knucklehead stuff we're dealing with, and it is the law, and it's a game that's played, and I don't like the game, but it sure makes me money. But to answer your question, how many service animals are required? That's a case-by-case basis. But I think 3 is kind of
Excessive.
what? 1, probably.
The other thing is, there was a case a couple of years ago, you guys probably know about this, where there was somebody who was deaf and he had a dog, and the HOA actually is the one that brought the case against him, and he couldn't show how the dog assisted him with his disability, because the dog barks and you can't hear it. So it ended up that it was ruled that it was just a pet. They actually had a different finding, but they ruled for the HOA that the dog couldn't stay. And so just because you are disabled doesn't mean that you get an animal, because you still have to show how the animal assists you with the disability. So
for the buyer representation agreement, when you state like a commission amount, and say like 3%, but the I guess the final property that they end up buying like only pays out 2.5%, like what happens in that case? So are they on the hook for that 0.5%?
So the 2.5% gets credited against the 3%, and technically the buyer would be on the hook for the other half, but most of my agents say, I'll waive that.
So do you like on that paper, do you say waive it or switch or change it and then like initial it?
My agents don't. They do an addendum for each particular property.
Okay.
But most of them don't put 3%. They put 2.5%, because the 3% scares the buyers. Go for it. If you can get it, get it. That's what I say.
Back to the dog issue. Did you say that you can't get a security deposit for a service animal?
I said that the new case that came out, basically saying that you can't have restrictive rules of increased rent, like more rent, or increased pet deposit, and so on and so forth. So it came out really pro letting the tenant have the animal without any additional conditions compared to the other tenants in the building.
So if you can't get a security deposit for the animal, then if they do damage, you're just out of luck?
No, you have your original security deposit. That's
Right.
why I recommend getting the maximum the law allows, regardless of the dog.
And I don't think it's ever a good idea to get a pet deposit.
No.
Because if you get a pet deposit and the pet dies, they'll come to you and say, I want my deposit back. And you haven't gone in and looked at it. You don't know what damage the dog has done. And then the next thing you know, they've gotten
Another
rid
dog.
of the Chihuahua's dead, but they've gotten Marmaduke. So I never think getting a pet deposit is a good idea. If they're getting a pet, you always increase the rent, because you don't have to give rent back. And you get the maximum security deposit you can possibly get, and then you have full coverage. Yes, we'd be happy to let you have your 2 German Shepherds. Our rent will be, increase it.
That was actually my question. Pet rent, not a disabled person, but just regular pets. Do you guys have like a range, like a small dog versus a big dog? Like how would
There's
you?
either AOA or CAR or AGLA has a pet addendum. Me personally, I don't deal with the problem. My policy, my company, no pets. I had a tenant I really wanted, super nice guy, great credit, et cetera, responsible, good guy, and we're getting ready to do the deal and create the tenants, and he says, well, I have a dog. I went, well, our policy is no dog. I'm thinking, nah, doggone it, deal's going to go through, going to fall out. But I'm going to listen to him. And I said, well, we have no dogs, but I really wanted him. I wanted to get the place rented. What kind of dog? He says, pit bull. Like, oh, no. No, wait a minute. It gets better. And he says, no, you got to meet the dog, Mr. Thompson. She's a wonderful dog. I said, pit bull dog, no. The place, they had a yard, and it was big enough for the dog, so we could accommodate the dog. I said, all right, I'll play along. I don't want to, burst the guy's bubble. He's a nice guy, but deal's not going to go through. Met the dog. The dog was perfect. And went right up to her, and she's just a friendly little thing. Well-trained, well-behaved. Tricks, and the guy was a perfect dog owner. How many dog owners are perfect? This guy was. I couldn't believe it. And the dog was perfect, pit bull. I said, geez, you know, am I in a dream here or what? I said, this is what we're going to do. So, you know, I want you to be a tenant. Here's the deal. And see if you want to take a tenant. The no pets clause is going to say no pets. That's what the contract's going to say. No pet addendum, no pet deposit. The contract's going to say no pets. I'm going to, as the owner, going to turn a blind eye to the pet. I said, if I just change my mind, no pets clause is enforced, and you have to get rid of the dog or move out. I said, but I won't change my mind, provided she's the perfect pet that she appears to be, and she stays that way. And I mean, no growling, no barking, no, you take her off the property to do her business. If I even smell urine or smell dog, I said, she's going. I said, this is the way it has to be because we got other tenants in the building. If she just you're walking her, she scares some little kid because she's a pit bull, she's a big dog, just walking. She's got to go. I said, that's pretty tough. Do you still want to stay? You know, still want to do the deal? And he says, yeah, I'll do that. I went, okay. So we did the deal. Dog was perfect. He stayed for 4 years. Never had a problem with the dog. Now that's an extreme exception. and as I was doing the deal, I go, this is not going to go well. Something's going to happen here, you know. And so, but you know, business. We got to make the business decision. So that's what I recommend. If you're gonna break the rule, no pets. Leave it no pets. Turn a blind eye. So you have the option now in rent control. You may have a problem over there, but this was non-rent control. So that's what as a management style at 3%. Don't be creative in this hardly at all. That was somewhat creative. Okay.
And I've let little dogs at $50 a dog. But I don't like, I mean, I own 2 large dogs, but I don't need them in my rental units.
Oh, and on that issue, what you talked about, your question, I didn't answer it. Yeah, the rent was going to be $950 for the big 1-bedroom that he was renting in a not great neck of the woods. And I raised the rent by $50 to compensate for it. So the rent, I said, and the rent's going to be $1,000 versus $950. So I just changed the contract. Okay, yeah, he was happy. And dog was perfect. Amazing.
Dog owners love their dogs,
do.
and they'll pay anything for them. So I don't think that I would give a range. I'd just say, you know what, size them up.
Yeah, 2 questions not related to each other. The first one is with the Estoppel certificate. Can the seller be in default if they have a tenant that just will not provide an Estoppel certificate or they can't get it signed?
Oh, me?
Yeah.
If you have a CAR contract that's got the box check that requires that seller's tenant to do it, the burden is on the seller to do it. Now, and then he says, the seller won't sign it. I've got a lawyer who's done a 3-day notice perform quick to get him to sign. He still won't sign. What do you want to do, buyer? Do you want me to evict this guy and credit the money through escrow and close the deal? Or do you want to forget about the Estoppel certificate? What do you want to do? You can force that tenant to sign one or evict him. That's if you have the box check. Did that answer your question?
Well, I mean, if they have a lease that doesn't state that the tenant needs to sign an Estoppel certificate, my concern is that the seller can be basically in default of the contract if they can't get the tenant to provide it.
And the buyer can say, no, I'm not kind of a tough deal, tough bargainer, but I'll walk away from this deal. You don't give me a Estoppel certificate. They're part of the deal. They're in escrow instructions, and you're not giving me. It's one of the contingencies, and you're not performing, seller. I doubt that they're going to walk away for that. And what I would I say this to lots of realtors and lots of people buying and selling property. This does not have to hold up the deal. I mean, look at the big picture. You got realtors and banks and loans and all this stuff going on. And you can start an eviction and sell it along with the contract. A lawsuit is a personal property. The contract is personal property. So you're buying a lot of stuff when you buy rental property: the land, the building, the contracts, which are personal property, and any lawsuit. You can buy that lawsuit and say, and I said, get the seller to, transfer it. It's ongoing litigation. You want to close next week. Well, okay, have him start it, and you finish it, and have him give you credit through escrow of $1,500 or $2,000, and do the deal, and then come back to me, and we'll finish it out.
This goes back, though, to what Jim was talking about earlier, that sellers should know their contract, and the seller should know that there's no provision in that contract to require the tenant to do an Estoppel certificate, so they shouldn't agree to give Estoppel certificates, or they say, I'll work as hard as I can to get them, but I won't be obligated to provide them. So that's how you would get around that.
Okay. Second question I have is just in regards to fee. When you've got a buyer that says, I'll give you a certain amount of fee, and then you have a seller that does it as well, I mean, how do you, in full disclosure, what are you supposed to do in those instances when those 2 things line up?
I'm not sure that I understood the question. When
So
you have a
if you've
seller
got
that's willing to pay you a piece and the buyer's willing to pay you a piece?
You've got a buyer that says, hey, if you can find me a property, I'll give you 2 points. And you've got something on the other side where someone says, hey, bring me an offer, I'll give you 2 points. how do you, in full disclosure, what are you supposed to do in those instances so that there's no issues for the agent?
You're a dual agent.
Yeah, I mean, you're a dual agent. The law says you have to disclose your compensation, but it doesn't say you have to disclose how much. So I think you'd have to go to the seller and say, 2 points is great. Buyer's giving me something for his side, so that'll work out great. And you can tell the buyer, 2 points is great because the seller's giving me something for his side, but don't worry, I'm not getting excessively compensated for this.
Hey, thank you guys so much. It's great information. I got one question. Nowadays with Zillow, Trulia, and all those kind of things going on, there's a lot more people who want to manage their own property. In other words, they want to rent the property out. They don't want an agent to help them. They want to do it themselves, and you provide the buyer. There are a lot. I don't know what kind of forms. They got all kind of different forms. Do you guys have any recommendations as far as that is concerned? What to look for and what to do?
So the landlord is representing themselves,
Right.
and they're not a realtor.
They're not realtors.
So CAR allows you in a transaction that you're in to provide the contracts to the other side. I would be very pushy to the landlord to say, here's the CAR lease, and push that onto the landlord. But again, that's okay. You represent the tenant. It always has your name on it, right? And how many times have you been in a deal where the landlord's agent said, I'm going to put together the lease? So it doesn't matter whose name's on the bottom of it. As long as you're in the transaction, it's okay. Now, if you go and print it out and hand it to your friend who says, I'm going to do a lease, and you're not a part of it, now you've violated copyright laws with CAR, and you've violated your rules with the MLS, or with the board. So you can't do that. But if you're in the transaction, you can push the lease onto the landlord. And I would strongly recommend that if they're just going to go off the internet and pull something, your tenant doesn't want to be there. Because that just shows also that they're not conducting their business as a landlord, as a business. They're just doing it as a sideshow.
In this case, to that same question.
Thank you.
Who's paying commission then if you're bringing in
Well, just because a landlord isn't wanting to be represented doesn't mean they won't pay commission. There's lots of landlords that do for sale by owner or for lease by owner, and they'll still pay a commission. But you'd have to negotiate that, right? You need to get a commission agreement. There is a lease lease. Come on, somebody tell me what the name of the form is. No. It's a commission agreement for leases. A lease commission agreement, LCA, I think. I just don't use that form very often, but I think it's called a lease commission agreement. So it's a commission agreement for that situation. And you'd go to the landlord and say, I have somebody who wants to rent your property. Will you pay the commission? Convince them why it's a good deal. You're going to get the California Association of Realtors lease.
My question is for Kelly regarding getting the proper signatures for LLCs and trusts, etc. Sometimes the grant deed does not say all the members. Do we need to get other documentation, like from a corporation, that shows that? If so, what should be asked for?
Yeah, the grant deed won't show you who's required, but it will show you that there are signatures on there. So you can look at it and see there are 3 signatures, so you should expect that you're going to need 3 signatures. But yeah, you can get documentation from the LLC. They can give you a secretary certificate that tells you who the authorized person is. They could show you their operating agreement that tells you who's authorized. And you as agents are not lawyers, right? Don't pretend to be them. You're really bad at pretending that. So take that documentation and go to title and say, can you tell me, do I have the right people? And they will be your lawyers. And you say, yes, that's the right people, and then you go and do it.
Thank you.
Good question.
I got a question.
Okay, hold on, 1 second.
So I have a building, I have a tenant moved out. I have a new tenant who's coming in, ran his credit. He had a BK bankruptcy, and his credit is 480. So I'm going to turn around and say, I want 4 months worth of security deposit, or I will not allow you to come in. Can I do that?
Call me and make an appointment. No.
And bring your checkbook.
It's not free. No, of course not. No, what you can, good question. You can collect legally in California up to 6 months prepaid rent.
At least 6 months.
Yeah, six months is about, I wouldn't go any more than that, plus the deposit. So if you got somebody that you really want to rent to, and he's got horrible credit, You can collect 6 months prepaid rent and the full deposit, and off you go. I had a landlord had a mansion, I mean a mansion in PV that he owned, and he moved to Florida. Well, he kept the mansion, he rented it out. The guest house was bigger than my house. This is huge. And he rented to a guy who had horrible credit, and he knew, this landlord knew the law, and he collected 6 months prepaid rent at $11,000 a month rent and full deposit. And he knew after about 7 months, this guy's going to flake out. The guy wasn't a drug dealer or anything like that. He was just irresponsible, kind of artsy kind of person, maybe, not a good business person. And he came to me with this eviction. I go, I want you to evict somebody out of my mansion up in PV. And what's the rent? $12,000, I think is what it was. And he says, I collected 6 months prepaid rent and the 2 months security deposit. I'm okay with it. And we had to evict the guy. And we did it. But he was not worked up about it because he already had his money. So that solves that problem. It's not very common where you're going to rent to somebody with bad credit. That's usually a red flag, no thanks for playing. That's a legitimate legal reason for denying tenancy, is bad credit.
And when you deny for that, you have to give a form. It's called a DRA, denial of rental application.
Right. And the basis is, insufficient credit or poor credit, that. It's not discriminatory.
And when you collect 6 or more months' rent, I always tell my agents, don't have it all paid up front. I mean, pay it up front, but don't have it apply up front. Apply it every other month.
That's
because
good.
That way you know if he's going to flake out by month 2, right? So apply it to month 2, a month 4, month 6, right? And then he's still got to pay in between. And that way, if he's going to flake, you know right up front, and you've got all this extra rent to deal with. And you've got that as padding.
If a purchase agreement on a commercial or investment property states that the property is to be vacant 5 days, before the close of escrow, and it's not when you get to that point, what recourse does the buyer have in that situation?
Well, I think they could call it a breach of contract and say that there is a breach the seller didn't perform, and they could get out of the deal if they wanted. In usual circumstances, though, if the buyer's still interested in the property, they're going to try to make a deal, extend escrow, do what they have to do in order to get the tenant to leave, and so on and so forth, either an eviction or, there's nothing like writing that tenant a little inspirational money to motivate them to move. And so maybe the seller has to do that, to basically, get the tenant to cooperate. The seller is going to get all these sale proceeds. Go ahead and try to, make a deal with the tenant to get them out of there by giving them some money.
Okay, and then also real quick, what is the maximum deposit, again, on a commercial, industrial type property? What is the maximum deposit that might be collected? And, can liability insurance be mandatory as a part of that agreement on commercial, industrial?
I think, liability insurance is something that just about every commercial landlord can demand. I haven't heard of any cases where they couldn't, so I'd say that that's still in effect. I don't know if there's really a limit on commercial. I don't think there is. It's just residential that has a limit on the amount of security deposit. Of course, if you ask too much, the tenant's not going to go for it. They're going to say, I have to go down the street and find a different location.
Right.
But
Jim, you mentioned earlier about security deposit accounting that starts as the 21-day time period, which, by the way, is an extremely rigid time frame for those of you who've never encountered that before. You said upon lawful possession, that's a repossession by the landlord. So can you explain when that starts?
Good. Yeah, you have to know when the tenancy starts and what acts create the tenancy and when it ends. Basic Landlord 101. 3 ways to start a tenancy. You take 1 penny of rent. I said before, rent is a legal term. It's not just money. Rent is a legal term. Deposit's a legal term. Fees are a legal term. They're different things. You take 1 penny of rent, they're your tenant. That starts the tenancy. You have the tenant sign your contract. You haven't collected any money or nothing like that. They sign the contract, your contract, even though you haven't signed it, they're your tenant then. That starts it. Or you hand them the key. It's shocking that landlords and most people don't understand. The key is the key. I had a client who had a 4-unit building, was working on one. He had one ready to rent. And he's in there working on it, and a guy is raining outside, comes up, hey, do you have an apartment for rent? Yeah, I got one. And he gives him the key. Go down there and have a look at it because he's working on this other apartment. And about an hour went by, and he kind of came to us and said, where did this guy go? So he goes down, the guy's moved in. And he says, what are you doing? I just gave you the key to move, to go have a look at it. And he says, you can't move in, get out. He goes, you can't make me, I'm a tenant. I'm calling the cops. The tenant says, go ahead, call the cops. LAPD rolled down. No, did you give him the key? Yeah, he's your tenant. Didn't get the concept. Rent control property. No contract. Nightmare. Handed him the key. Okay, so that's when it starts. So these are critical stuff. You just can't, no, it's real. It's business. Okay, and so when does it end? When do you have to start? When does that 21-day clock start ticking? Lawful possession. When does it end? The tenant gives you in writing, I vacated the property, signed on this date. That's real rare. Okay, or they hand you the key back. I always tell my landlords and property managers, get the key, get the key, get the key. Judge over in Long Beach, judge up in Santa Monica, in his opening statement says the key. Talks about this, because tenants and landlords don't get this. The key is absolutely, it's a legally recognizable act of delivery of lawful possession, either from the landlord to the tenant, now you're my tenant, bang, there it is, or now it's, you have lawful possession of your property back that you own, landlord. It's no longer my home, the key. Or he's evicted. Those are the three things. Generally, I say it's either the sheriff or the key. Okay, and once you get the key from the tenant, or you get the sheriff's lockout, that clock starts ticking at 21 days right then. Does that answer your question?
Yeah, I have agents that contact me and say, well, the tenant moved out.
Yeah.
And so we need to go in there, but he hasn't called us, he hasn't given us the key, and I always tell them, then you don't have possession, and the landlord doesn't have the right to go in.
Right. Well, the last part is not entirely accurate. We're in the gray area. He's not there. Whether he's not, and I get this all the time, he's not there. Whether he's there or not's not the issue. The issue is, do you, as the owner, have lawful possession of that realty? He's probably still in the process of lollygagging and moving out. He's going to take 2 weeks to come back and forth, back and forth. He may be living somewhere else, but he's still got his stuff and lawful possession. He's still holding the key. And what do you do? Well, you can do a 24-hour notice to landlord's reasonable belief in abandonment. Okay? You can do a 24-hour notice, check the box, I think you're gone, and go in then, but you still can't take possession. Then when you do the eviction or the statutory abandonment procedure to get the property back, okay? But it's a gray area, so you definitely want to ask that tenant. Go ask that tenant, when can I get the key? You do whatever you can, be their best friend. When can I come over and get it? What's convenient for you? Do you want to leave them on the counter? Do you want me to come pick them up? I'd be glad. What time? I tell them, hat in hand, you want to be their best buddy to get that key in your hand because that's what you want. Or
We're going to take one last question. We're going to take one last question.
If you have exhausted your 21 days, but have not completed the renovations required due to damage, and you don't want to return the entire security deposit, can you give a letter with whatever you feel you can return and extend by that letter the time for completing the repairs needed?
Okay. Really good question. Very common. Lots of times it takes longer than 21 days to fix it up. You hope not. But the law says you have to base the security deposit accounting on actual invoices or on estimates. Or on estimates. So in that scenario that you're giving me right there, you should, within a week, after you get lawful possession, get everybody in to give you estimates in writing. What's it going to cost to paint, to repair, to do this, estimates. And then you got a good ballpark figure. Well, you actually got all the estimates. You add all those estimates up, and then you do the security deposit accounting. To answer your question, can I do a letter extending it? No. Short answer, no. One more thing. Never write letters to tenants. Never email your tenants. Never text your tenants. Never write notes to your tenants. Never. Okay. There's always an exception. I write one letter. I wrote one last Friday. I closed escrow on a building. There's a new landlord. Your rent remains the same, payable on the 1st and mailed to the new landlord. That's the only letter I ever write to tenants. How do you communicate with the tenants the lawful way? Can you call them? Yeah, most of the time you're wasting your time and harassing them. You do the right notice. Got a problem? There's a notice. There's a problem, it's in your contract. Very simple. Landlords are texting and emailing. It's virus. It's a virus. I had a property management company, very experienced property management company. We're going to trial on an eviction about a month ago. On the Friday before, we sat down, we do trial preparation with the property supervisor and the property manager. and I see what they're doing as far as running the business. One of the many issues was texting from the manager to the tenants. And I'm very direct with my property managers and realtors and property owners. I don't sugarcoat stuff. I said, this is nuts, And I went at them for like 10 minutes. You're doing this wrong, this wrong, this wrong, this wrong, this wrong. And they left. And I thought afterwards, man, your bedside manner's garbage, Thompson. They think you're a jerk, because you really went off on them hard. And we went to trial, and every single one of those issues came up at trial. The biggest one was texting. The tenant, no lawyer, pulls out his cell phone and starts reading each and every text for over 4 months from that manager. An hour and 10 minutes we're sitting there with this tenant's reading this. After about 30 seconds, I turn around and look at the manager back. She's like this. After 2 minutes, the judge is rolling his eyes at him. Aren't you teaching your clients, Thompson, about this? Now we got to sit here and watch this because I don't know what's relevant, what's not. I got to listen to all this stuff. And it went on an hour, a minute after minute after minute. After about a half an hour, I turned around. The manager's crying in the back. Okay? Hour and 10 minutes. Nothing was relevant, but because she's the agent of the owner, everything she says could be relevant. And he's got to just find one little thing that's an omission or damaging to our case. We have the burden of proof. The judge had to listen to it. Graphic example. Fortunately, nothing that she put down. But as I'm thinking, how much time out of this woman's life is she spending doing this to this one tenant about business? How much communication do you need to do? Communicate with them, do the notice. You can call them, yeah. You can go up to them, knock on the door, talk to them, yeah, you can. Pretty inefficient, but it does work with rational tenants. You do the right notice. If there's something you need to have happen, there's a notice for it.
Thank you, Jim, Holly, and Bill. Appreciate you guys' time from your busy schedules. Thank you guys all for coming. Make sure you pick up their cards.